But so let me introduce our speakers. The subject for this panel is, and the official title of it is Gleaning Insight from the Antitrust Cases Using Machine Learning. And you will hear about how you could actually teach antitrust to an algorithm. To discuss the matter, we are joined by, and I will try my best with the Italian accents, Giovanna Mazzarotto, who is an academic fellow at the Center for Technology, Innovation and Competition at the University of Penn, and also an affiliate at the UCL Center for Blockchain Technologies. We are also joined by Ashwin Itu, who is a professor of computer science at the University of Liège, and more specifically, HEC Liège. On my right, we have Daniel Lina, who has a joint appointment at the Northwestern School of Law and the School of Engineering as the Director of Law and Technology Initiative. I think it's fair to say that Dan is one of the leading scholars in the field of computational law. And we are also joined by another of my favorite scholars in the space. He has a website which is absolutely fascinating. I hope, David, you can talk about it. David Colarusso, who is a director of the Suffolk University Law School Legal Innovation and Technology Lab, where he's a professor of law. So what we have decided is to first give the floor again to Giovanna and Ashwin for their presentation, and then we'll move on to the discussant. And again, feel free to just drop your questions in the Q&A, and yes, enjoy the talk.
Okay, so thank you so much, Thibault. If it is okay, I will share my presentation. Okay. So thank you so much for having us today. I'm really delighted to offer you a few thoughts on a subject that's of direct and immense interest to all of us in the antitrust community. The takeaways from our presentation and our paper is first, AI is everywhere. Today, AI is from Siri speech recognition to AI techniques that suggest what movies you might like on Netflix. And AI can be used also in the field of antitrust, because we have more than a century of experience in enforcing antitrust law that we can exploit by using AI algorithm. And the third takeaway is that our paper experiment aims to pave the way for future AI system in the field of antitrust. So the reason why I believe is fundamental to reason on how to exploit AI techniques is because, as Richard Posner observed days back to 2001, antitrust enforcers do not technical resources and do not move fast enough. So the idea of exploiting AI stems from my book on antitrust settlements, in which I collect data related to both jurisdictions, the US and Europe, and I perform a multi-regression analysis to predict possible effects of a Google breakup using AT&T coefficients. And differently from most of scholars that were exploring how AI could be used to engage in anti-competitive practices, I was more interested in exploring the question, why don't we use AI to fight antitrust practices in today's data-driven economy? So I discussed the idea with Ashwin, and we translated this idea into a reality. And we developed a proof of concept that was built by using data from FTC antitrust cases under Section 5 of the FTC Act, and we adopt a supervised learning techniques. The project was developed in 4 stages. So first of all, we collect data and we define the most significant variables that could be interesting to detect useful patterns in our data set. We code the data and we clean the data. And afterwards, we ran machine learning algorithms to see whether we were able to find useful patterns. And we assess the results from both a technical and an antitrust perspective. So now I will leave Ashim to proceed.
Thank you, Giovanna, for this introduction, and good evening or good morning to all of you. So as my colleague said, we were trying to build an AI algorithm that could understand these antitrust cases. And the first step was to create a data set of these cases. So we tried to formalize each one of those antitrust cases in terms of a number of variables, which you see on the screen here: the year, the industry, the conduct being investigated, the remedies adopted, and so on. And in all, we had 72 cases that were ruled under Section 5 of the FTC Act that constituted our data set. In the next slide, you can see a list of all our variables. Can you just switch slide, Giovanna?
Yes.
So these are the variables that we use to describe each one of those cases. As you can see, we had a maximum of 4 types of conducts, a maximum of 5 remedies, because the cases we examined had a maximum number of 5 remedies and 4 types of conducts. We had the year, the industry, and of course, the case name. So this schema describes how we formalize each one of those cases. And in the next slide, you can see examples of the cases. Maybe just switch slide there. Here you can see examples of each cases. Of course, you can only see a partial view of all the variables that I described earlier, which were used to describe these different cases. Right, so now we have defined our variables to describe each one of those cases. We had 72 cases in all. And as you will see in the next slide, we will start to first explore our data. The main aim in doing this kind of exploratory data analysis is to detect outliers, inconsistencies or incoherencies, irrelevant variables, and highly correlated variables. You don't want your learning procedure to be biased, for instance, by variables which are highly correlated to each other or which have extreme values, which are outliers. One way to address the specific issue of trying to find out which variables tend to be correlated with each other is by a heat map. I just showed you an example on the next slide. We don't need to understand the chart here, but you can read more about it in our article. From this heat map, we saw that indeed our data was correct. There were no outliers. There were no variables that were specifically not correlated with each other. Then we said, now it's time to start applying our machine learning algorithm. So our aim here is not to make any predictions. So as you would see next, on the next slide, we are mostly concerned in trying to find patterns in our data. And since we are not trying to make predictions, we could, but it was not our aim here. Our aim was to try to find patterns that characterize those cases. And in machine learning parlance, we are doing unsupervised learning. And one popular class of unsupervised learning is clustering. As you can see on the next slide, there are several types of clustering algorithms, k-means, k-mode, and the bisecting k-means. They all adopt more or less the same operating premises, which is as follows. They take each case, which is described by the 16 variables. Each of these cases is treated as a vector, which is plotted as a point on a multi-dimensional space. So each case or each proceeding is now a point in some space. And then we compute the distance between those different cases, because it's quite easy to compute the distance between two vectors. Once we have the distance between the different cases or the different vectors, we can group them based on their similarity. These cases which are more distant are going to be less similar, and vice versa. On the next slide, you can see the groupings of the different cases. So on this particular graphic, all dots represent one case, and similar cases have similar color. That is, in the vector space, the distance were close by to each other, and they have been grouped into a single cluster. Here we have defined to have 4 clusters of similar cases, identified on this graphic by different colors. And note that each dot here is a vector of 16 variables, which corresponds to each case, which I have showed you earlier. You can just move on, Giovanna. Thank you. Right, so now we have applied our clustering algorithm on our data set of cases. We have found out which cases were most similar to each other, which means that for each case, we could identify a cluster to which it belonged to. And then once we have this information, we could determine, for example, that the first case on this slide here, as well as the 4th one and the 5th one, belong to the same cluster, that is cluster number 2. So the algorithm determined that these cases were similar to each other, they were not distant in the vector space, and therefore it grouped those cases into a similar cluster, which was now cluster 2. Obviously, these results are quite dry, so they need some kind of antitrust interpretation, which I will leave my colleague Giovanna to continue with that.
Thank you so much, Ashin. So as mentioned, we evaluate the results also from an antitrust perspective, in addition to a technical perspective. So the cluster 1 was interesting because it detects data and computer industry in the together with the healthcare and pharmaceutical industry cases. The most frequent practices investigated in this cluster were price fixing, exclusionary conduct, and the remedies suggest were contract limitation and compliance obligation. So cluster 2, instead, it's interesting because concern cases in which were investigated at least 2 anti-competitive conduct. Conspiracy was the most frequent detect conduct, and the remedies, it's interesting because as remedies was suggested limitation in the exchange of information as the most frequent, one of the most frequent remedy. Cluster 3, it's detect the majority of cases concern 1 investigate conduct. Indeed, it was suggested no remedy besides reframing from the anti-competitive conduct. And most frequent practice were agreement to compete and invitation to collide. The last cluster, cluster 4, it was dominated by cases in healthcare and pharmaceutical industry, and detect as main antitrust practices price fixing, suggesting limitation in exchange of information as remedies, which make perfectly sense from an antitrust perspective. So the idea was, okay, let's see if what the algorithm is suggesting, the patterns, makes also sense from an antitrust perspective. And it seems that it makes. So I believe, and we believe, in a sense, our paper, as mentioned, aims to pave the way for future AI systems. because I think there is no alternative in the enforcement of antitrust in today's fast-moving technological markets, because as mentioned since the beginning, antitrust agencies need to move at the same speed of markets to be effective. At least this is my thought. AI has a lot of limits. Our experiments has limitations, but these should not prevent the exploration of these systems also in the field of antitrust. And I believe that our message today was clear, and to you was clear and straightforward, in a sense that we don't think that AI can replace antitrust agencies such as the FTC, but we believe that the AI systems can turn out to be an invaluable antitrust tool to enforce antitrust principles in today's fast-moving technological markets. Thank you.
All right, thanks a lot.
And we look forward to receiving your comments and your thoughts, because yeah, seriously, it was a nice experiment. And what I can tell you since the beginning is that it was great to work together to combine our expertise in a way in this project. And I hope, yeah, to hear that there are other projects on their way now.
And I remember that one of the first questions that I asked you in the podcast is how long did it take and how costly was it? So something to be discussed, but I'm sure Dan and David's going to have comments and potentially questions for you. So I will give the floor right now to you, Dan, so you can kick us off with a few of the discussion points.
Sure. Thank you, Thibaut. And thank you, Giovanna and Ashwin, for this work. Let me see if I can share my screen as well. And I've got just a couple of slides here. So yeah, I thank you for your presentation. I really appreciate the combination of law and computer science expertise that it takes to work on projects like that. So it is great to see the continuing work that's happening in this space. So I just wanted to kind of use my 10 minutes to walk through some of the contributions and a few questions that I had, and maybe also I'll highlight some of the things that from the audience perspective, I might be repeating a couple of the things that you said, but just want to kind of try to reinforce what some of the contributions are and what exactly you did. And so, you know, the contributions, I think, are demonstrating, you're illustrating here the way that machine learning tools have the potential to aid antitrust agencies in preliminary screening, analysis of cases, and potentially ultimate decision-making. As you said, you weren't trying to make predictions here. This is a first step. You're trying to lay a foundation, demonstrate the application of some methods, demonstrate the validity of those so that additional work can be built on top of this. I think it's interesting that you pointed out as well that it wouldn't just be necessarily antitrust agencies that would use these tools, but regulated companies, right? And so as a fan of computational law, generally this idea of creating tools that can not help just the regulators and enforcement agencies, but also individuals and companies who are subject to law and regulation better understand how, you know, what's expected of them and how they should be acting in the environment is important. And then also your use of unsupervised and supervised algorithms for legal analysis are contributions here, I think. Your research questions, and you laid them out very clearly in the paper, and I just want to talk about each of these research questions just a little bit. Asking the question about whether AI can assist antitrust enforcers, and then also this idea of accelerating and harmonizing globally enforcement of antitrust principles. And then you had these sub-questions about the extent to which characteristics can be extracted from antitrust cases, whether patterns can be identified. And then you did raise an interesting question about bias that I'm hoping we can talk about a little bit in this discussion as well. So on that first couple of questions, I think that you demonstrated, you showed some work here to suggest that we can extract characteristics from past cases and identify patterns. One of the things that I did want to talk about a little bit is I'd like to learn a little bit more about how you selected these cases. And just for the audience, I would note just to highlight again that when you first started, you were looking more broadly at European cases and cases from the Department of Justice Antitrust Division and the Federal Trade Commission, but it had to end up settling on just Federal Trade Commission cases because the heterogeneity across those different types of cases, and you weren't really finding any patterns. Now, you said you trained the algorithm mainly on consent decrees. I'd like to understand a little bit more about that, about which cases that were used. When I went to the FTC website, I came up with, I think it was 234 cases in that time period. And so you can tell us exactly how you selected these cases. Maybe that was the full population, but if it wasn't the full population, how did you select them? And you already walked through the variables that you used and talked a little bit about the different methods. I thought it was interesting. It was really interesting when I was first reading through that remedy 1 was not relevant, and that really surprised me. But then I saw that later on you talked about it, that the way you coded remedy 1, it had to do with the FTC requiring that the entity refrain from investigated conduct. So there was no variance across that variable, so you ended up discarding it. And so I followed that. I did have a related question though, because I know that the remedies were random, you said. And so I guess there's some arbitrariness in kind of deciding like whether a particular remedy would be classified as remedy 2 or remedy 3. And I wanted to know if that was the same case for the type of conduct as well, because I think that could potentially affect the analysis. And again, I think you summarized so much work that you did in this paper in 20 something pages and the appendices, the 10 appendices, which I thought were really helpful. And I'd just like to understand more about kind of how these variables are constructed for the analysis. You talked about a couple of these charts already, but I'll just stop here on this one about, I think this question is important too, because the type of conduct, it's really interesting to see that the second category for type of conduct, it appears had almost 4 times the impact as the first type of conduct. And I'm kind of curious, like, is that an artifact of the way that the cases were being coded potentially, or what's going on there that it might help us better understand what's happening? So on the methods, I was curious about that. I appreciate your analysis of the cluster. I think there are some interesting trends that you're observing. I think this is one of the challenges we have here is like when you're doing this kind of work, well, how do we really know how well the model is performing, right? I mean, so we've got some anecdotes about some of the groupings and things like that. And how can we have a better sense on whether the model is picking up on some sort of signal versus just some noise that may have been introduced in the way we put together the data. On your questions, your initial questions about accelerating and harmonizing antitrust principles, I think the accelerating part, right, there's work still to be done to show theoretically, I think these methods can help. And then it's important to consider the processes, who's gathering these facts, who's applying the labels to the facts, things like that, what's not being enforced, right, what's in the data, what's missing from the data. And as you discussed in your paper, there are challenges with harmonizing. And I think asking these questions about harmonizing antitrust principles globally, what kind of progress we made there is very interesting. This bias question, you raised it briefly in your paper, and I think it's a really interesting question to ask. And there's been a lot of research, or a growing amount of research, I should say, being done at Stanford. David Engstrom and Dan Ho have done research on algorithms in the administrative state. Carrie Colanisi at the University of Pennsylvania. I think that, so when we start using these algorithms, asking questions about potential bias, and I think Compass is an example of bias in the criminal setting. I think it's really interesting to consider not just bias and technical questions, but the fairness questions raised in Compass, because some have defended the methods actually even used in Compass, but yet there's some really challenging fairness questions. And I think, so you've laid out some reasons why antitrust can be a safer testing ground. If we're looking at efficiencies and competitiveness and things like that. And so there's some reasons to believe that antitrust could be a good place for testing these. I think we have to ask, though, then how much of that would rely on the assumption that protecting human rights isn't a part of it, right? And that's something that there's some normative questions about. And in fact, there's a lot of discussion now about thinking about the extent to which antitrust law should be thinking about things about racial equality and thinking about the ways in which there might be bias or there might be disproportionate effects of enforcement actions or failure to enforce, for example. So I think there's some interesting questions around bias. How might we test for bias? What sort of features would we need? What sort of data would we need? How might we get a sense for some of these antitrust decisions? Who's affected by them? Are there underrepresented groups that are disproportionately bearing the costs of enforcement action or failure to undertake enforcement action, for example? How might we assess impacts and potential harms? So those are a few of the things, and I just had a couple of wrap-up questions on slides, and I'll paste these in the chat after I finish here so we can have them top of mind after David concludes, and we can hopefully discuss some of these. But again, understanding a little bit more about how the cases were selected, if that was the whole population during that period of time of these Part 2 consents. The coding of the variables, understanding if the type of conduct was also had this randomness in it. I think it would be really interesting to talk about the limitations in using consent decrees to train algorithms to make predictions and wondering the extent to which, right, we know in the judicial space that if we look at the facts section of a case and use that to train a model to make predictions on outcomes, well, one of the problems is the facts are written when we already know the outcome, right? So that there can be some challenges there using that type of data for prediction. And do we have any sorts of challenges in data like this? I think we've got one other thing to kind of keep closing the gap here in moving forward is asking questions about what data is missing. And of course, there's investigations that don't proceed to enforcement action. There maybe are activities that should have been investigated, but were not. What are the impacts on people? Do we have data about that? There are plenty of things that are difficult to measure. Some would say impossible. I think we can come up with a lot of ways to measure a lot of things, but first we also have to identify those things that ought to be measured. We ought to collect data about. I just noted that you noted that during that period of time, you didn't think enforcement proceedings probably did not change much. And I think it'd be interesting to ask if that's a reasonable assumption. I mean, that'd be something else we want to control for over time. And of course, there were different presidents during that time. I've seen other researchers to suggest that maybe there were some changes in the way the FTC was enforcing Section 5. So that's just something to think about. And then just finally, right, I hope we can have some discussion about taking your research and talking about, well, where are we? What's the state of the art? And how do we keep working to close the gap between where we are and where we want to be with these tools? So those are some of the things I look forward to us discussing.
Thank you very much. Now the floor is yours, David, for more questions to be discussed.
All right, great. First, I just want to say you've done a yeoman's work here creating structured data from the FTC proceedings. Like that's like definitely you had to go in and do all that coding to get out that structured value. So great work there. I also liked seeing in the slide there, I saw some of the tooling you were using, Google's Colab and scikit-learn, both tools that I really like. In fact, I really wanted to get into the data and like dig in there. And so one of the things I really want to know is if your data set and your code is published anywhere for people to work with, because I think that would be very useful. And then I must admit, my comments and all my questions were sidetracked by a single slide in your presentation, and I need you to talk me down from this. So I'm gonna share here, and we can look at this together. Are people seeing the slide there? So this is where I really hope you can answer these questions. I look at this as the sort of the features and the targets. I assume this is where you were working with your after you had gotten your clusters. This was the data you looked at. Presumably also everything minus the target, so minus the cluster, was the data you fed into your clustering algorithms. The two things really jump out at me. One is that it looks like maybe there's a confusion of categorical and numeric values. So for example, under industry, I see there numeric values between at least 1 and 8. And if I'm interpreting right, that I suspect it means like you had one industry you called number 1 and the second industry you called number 2, but the biomedical industry is not 2 times the manufacturing industry. So I hope that's not what happened, because if it is, then I don't think you can get reliable information out of the industry column. I think best practice would be to take that and create dummy values for each of the categorical values. So assuming you said had eight industries, you'd have 8 dimensions. Each would be a binary value, and you would see that present. So I'm worried about maybe those got conflated. I'm also worried about the types of conduct 1 through 4 doing the same thing, but in piecemeal, and the remedies 2 through 5 doing the same thing. I notice in remedy 2, I see a remedy 1, and I also see a remedy 1 over in remedy 5. And the thing that also really worries me is I see remedy zeros and types of contact zeros always on the trailing ends, which makes me think that those are null values, which is to say that you're coding a 0 as a no remedy or no conduct in those 4 classification bins. And again, that would be giving a value to something that didn't have a value. Again, I think best practice would have been to take I don't remember what it was, 14 or 18 types of conduct, split those into 18 dimensions as binary classifiers. And so I'm just, yeah, I hope you can talk me down from this, because I'm worried that that basically means you need to throw out your industry, your types of conduct, and your remedy features. I think that also would help explain Daniel's concern here. It might be that the reason why code of conduct is showing most predictive power, because most predictive power in this case would be for classification in your groupings, is simply because that's the one with the most entries in it, as you have null values in the subsequent codes of conduct. So I really love the tooling. I love the work you did and the coding, the stuff. I love the idea of the research agenda. I just have some big questions about that underlying data, and I think I'll just stop there and look for your answers to that. So yes, thank you.
All right, thank you very much, David. I've also put the link to your website, codingthelaw.com. I'm not sure if you do have a new version of it, but in any case, it's open source.
It changes every year. And I also should make very clear the null value error. I have made that very publicly myself. So that is something that it ended up on on Boing Boing, and I had to retract it, and it was horrible, but it happens. And so yeah, there you go. That's that.
All right, thank you very much. I think I'll give the floor back to Ashwin potentially first.
Yeah. Thank you very much for this. I will stop the second question, which was in fact a very interesting question and a very pertinent question. I understand the concern, and in fact, you have to be assured that the values we use were categorical values. So 2 for tech industry and 1 for pharma. Doesn't mean that pharma is or tech is twice as important as pharma. So they're categorical values. And we did use dummy variables, which I didn't show in this slide here because it's going to explode the space we see for each.
Makes my heart feel a lot better.
Number of different values. Yeah. So I wrote partial on top for that reason specifically. And also what we did try to address these issues of categorical variables was to use a different algorithms known as K-modes, which is more suited than K-means for this kind of data. And we tried to combine K-means and K-modes as well. Then we stopped because it was getting too complex. But be assured that everything has been done according to the best practices. We did use dummy variables, sorry, but I did not show them on the screen. And that's a very important point, because many people tend to forget about those dummy variables and confuse numerical values with categorical values. Now for the second question about the type of context 0, I have to check with Giovanna on that. I think 0 had a specific meaning in our case. I don't recall exactly which one. I have to look at the data again, but it had a specific meaning, which I don't recall now. 0 did not mean no value or null or empty. It had a specific meaning. which I don't recall on the top of my head now, but I can get back to you on that later. And then, did you have one more question? All these technical questions.
I think those were the majority where it at. I did have some
I think
questions
those are
about
the two questions, right? And I can jump back to what was asked by Daniel earlier about the type of conduct, and which also asked David. So it's, as you know, all these algorithms, they have some randomness inherent into them, and whatever they predict, you shouldn't take it at face value, because randomness can be quite problematic sometimes, especially in that case that we had only 72 proceedings to work with, right? So what we did when we tried to assess the variable's importance was to try to run two different algorithms and compare whether their results were aligned with each one another. And what we saw was that the same variables were evaluated to be important by both methods, random forest and support vector machines, but the order of the magnitude were different. I think what I showed you on the slide, or what you showed on the slide, was the result for random forest, which showed conduct 2 to be most important, but the other algorithm, support vector machines, showed conduct 2 to be a second most important variable, I think. So they kind of align in telling you these are the top 5 most important variables that can be used to assess those cases. And it might be, as you said, that there was some randomness in the types of conducts in how the courses were ruled, and this is why the results show that conduct 1 was not as important as conduct 2. So just to wrap up David's question first, yes, we did use demi variables to convert those values into specific categories and so on. And then the 0 values don't mean null values, and we did try K modes, which is very commonly used for categorical variables clustering. And for Daniel's question, conduct 2 was most important, but which is difficult to take it at face value. You have to compare the results with some other prediction and see if they align or not, especially because you have randomness, which is inherent, and even more so, our data set was extremely small. And this could be one limitation of our research, such as small data set. And I was in a conference last week in South Korea, and they asked me more of the same question, which was whether we had considered cases that had been dropped. So that were begun investigation and then that were dropped from further investigation. And so this again tends to start to point out towards the issue of bias, because our data selection was biased, you can say it, because we focused only on the cases that were ruled, I think you call it a consent degree.
Yeah.
But I will leave it to my colleague to elaborate more on these legal aspects. And one last thing before I forget, yes, the codes are available on Colab, and I think the data set also is available somewhere via a link in our article. Otherwise, we can publish it online on GitHub also.
So yeah, if I remember, so this one of the first article that we published, but we had a link to all that in the paper somewhere. I can't recall where exactly.
I didn't see it in the appendix, so perhaps it's hiding enough.
No, it wasn't in the appendix. It was a link because it was too big, and we thought, well, it has to be short. So this was our trick to put it outside and pretend we didn't have more than 20 pages. I would just ask a question before I give you the floor, Giovanna, and the question is actually for you. And indeed, someone, and it's here, Diana, is asking the question about the fact that by definition, you've been labeling data using the anti-competitive conducts that we know already, right? And so how would you envision using a similar technique to capture novel practices, whatever that means? And you've been working with supervised and unsupervised machine learning. So maybe it's the time for you to discuss all that and to answer Dan and David's questions. So Giovanna.
Perfect. First of all, thank you so much to both of you. Our comments and questions like yours that help not only us, but also other researchers that are working in the field and help us in understanding where we should focus our attention to improve and to keep exploring these new techniques in different fields, also in the field of antitrust. So with respect to your first question, why the FTC? In a sense, as we wrote in the paper, we initially thought to include other agencies, but the issue that it was the first experiment, and we thought it was more useful to focus on an agency, because if you look at the other agencies, all the other agencies, just if you look at the rule of laws that they apply, they have differences. And they have different powers. So the chance that we were able to find useful results from combining data from agencies from all over the world was really low, I guess. So similar to a situation in which, I don't know, for example, I receive advertising that is different from someone else. So is trained with data, with my data, in a sense, machine learning. We thought, okay, let's train our machine learning focusing on only one agent. And then if it works, we might explore the opportunity to extend our data set and including other agencies. Honestly, I don't know what are the concrete possibilities that we find interesting patterns, because as mentioned, we focused on FTC antitrust cases under Section 5 of the FTC Act, but if you need to include the other agencies, you need to include different rules of law, and only for the rules of law create different variables. And there are, but for sure, it's something that it's interesting if someone is willing to explore the idea to combine and build an AI system that include all of agency. I would be very interested in knowing the results, but for us, it wasn't worth the effort, I would say. As first experiment, as first proof of concept, we decided to narrow our investigation to the FTC. Mainly consent degrees, in a sense, we include a few cases that weren't settled, including Google, but 90% of no mergers FTC, more than 90% of no mergers FTC cases are settled by means of consent degrees. So this is why the algorithm was trained, in a sense, we used mainly cases related to consent decrees. So I emphasize this point just because it was something that I thought it was interesting to note, in a sense.
Giovanna, can I jump in and ask a quick question?
Yeah, absolutely.
So the 72 cases, just so I understand, was that the full population of a certain type of case from September 1st, 2005 to November 30th, 2019? Or was that just a sample of some of the cases? And if you sampled, how did you sample? I'm just curious.
Yeah, sure. We use the FTC database, and in the FTC database, you can there are some filters, so no mergers and that I recall were FTC cases. Now you know that the FTC also enforce rules for consumer protection. So we focus only on antitrust, no mergers, and to my knowledge, include mainly FTC consent decrees because this is the practice in a sense of the agency. But I'm happy to double check in a sense. Thank you so much for raising this point in a sense that we started this project years ago. So to my knowledge, we include cases using the FTC website and looking at Section 5, no mergers in that time frame. So, but thank you very much for Daniel. I really appreciate, and it's something that
I have a question for you, Giovanna and Ashwin, and then I have a last question, which is in the Q&A, which I want to ask to all of you. But before that, there is a question as to whether there is industry standard for clustering techniques and whether they could be used to structured databases that exist already. I believe that Joost may be working on a structured database with EU antitrust cases. And so how easy would it be to, in a sense, translate your methods to the EU case law? And if I may just take 20 seconds for a public call, something that would be very helpful would be for the European Commission or another institution to create a database with at least all the case law coming from national countries, which is something that we don't have. Of course, the language barrier will still exist, but it would be nice to have that. And I see no reason why this couldn't exist. So I just wanted to put that on record. But going back to my question, would it be possible for Joost to use some of your technique and translate that to EU antitrust?
From my point of view, yes, in a sense, Ashwin is much better than me in responding a technical question. But what I envisage, in a sense, is, as you mentioned, is the construction of a data set that enables antitrust agencies to collect data, and if they want in the future to run machine learning algorithm, they have already data collected, and they should start with the new cases that on which they are working. So this is really something that I hope the agencies will start, no matter like what techniques you use. I think just the data collection will be extremely helpful. The FTC is very good because you, and also other antitrust agencies, so you find many public data. So, but for sure, it will facilitate the work of many, in a sense, if they can directly, and also, they will create a data set that is more reliable, and also it will help to avoid inconsistency. So,
Ashwin, any views on
if
that?
I would try to answer your question and at the same time address a few questions on the chat. One of them asked, I would try to read it, whether we should use data analysis based on theory on what is.
Oh, that's the question I want to ask next.
Is
so
relevant for antitrust. So I will try to start addressing it to prepare myself better. So yes, in fact, so how does it apply to your question on the EU jurisdictions? First thing that we need to do is to understand how can we formalize a case. How does antitrust or competition law in the EU represent a case, and how can we operationalize variables to represent that case? In our study, it was our first study, so we selected 16 variables that we deemed best describe a case. So for the EU jurisdiction, I think the most important thing to do is to understand how is a case characterized. How do antitrust enforcers characterize a case? So get into their head, try to see how they formalize a case in terms of variables, how do they structure it? Then once we have that structure in mind, then I think that the same algorithms that we use can be applied to any data set that is at hand, except of course if we need to deal with textual data, because those demand a different kind of approach. But initially, I think we could apply the same algorithm to numerical or to categorical data regardless of the jurisdiction from which they come from, as long as we can formalize a case correctly. And there was, sorry, there was one more question on the chat which asked, which was telling that we applied our algorithm to known cases. What happens to new cases, I think.
New type of practices.
New type of practices, sorry, yeah. So in fact, yes, this is also a very good question, because machine learning, especially supervised learning, is trained on past data. In unsupervised learning, we learn patterns from past data which have been created by human beings. Algorithms cannot learn anything on their own. By themselves, I mean, from scratch. They have to be fed with data. That being said, if we had to detect novel practices, one approach using what we have built so far would be that, given a new case, take that new case and see to which cluster does it belong. If it does not belong to any cluster, then it might correspond to a new type of practice which has not been seen before. So this is one way in which we could do that. I can't think of other ways now, but this seems to be a promising way to address this issue.
I have also a comment, and if I have time, I would like to address other questions.
I will just ask you the question, and so I will give you 2 minutes so you can wrap up, so you can also address your comments. But so the question which is in the chat, and I think this is a crucial question, asked whether or not we should work with existing economic models. And I think this, relates to the question of interdisciplinarity when we conduct such projects. What I can tell you, my perspective on it, is that we do, first of all, have economists who have written papers for us, and we have some more coming in 2022. And they look entirely different from papers written with no economists. You will hear tomorrow from MIT scholars coming from the field of physics, computer science, and law. And you would see that the way they approach antitrust, and here especially merger control, is totally different from the way an economist trained in the field of antitrust will approach the issue, and even more so for an antitrust lawyer. So I think the two might be complementary. But my question to you all, and so Giovanna, you can also address your point in about 1 or 2 minutes each, so we can finish on time, is the following. When you are working on computational law and related projects, have you ever worked with non-computer scientists in those projects, meaning, a philosopher or someone specialized in sociology or an economist? So what is your experience in doing all that?
Okay.
So,
do you mean for this specific project or in general?
For any computational project that you may have encountered?
No, I'm like particularly lucky because I had the opportunity to work in an economic consulting firm in addition to law firms and to work also with people with different background. So this experience with Ashin was particularly useful because yes, we built a proof of concept, and in other situation I went so far. And honestly, I love the idea of having philosophers, and I always dreamt to study more physics. My passion is linguistic, and when in my spare time I study linguistics. So it's really something that I will encourage to have people with different backgrounds, because they can provide different perspective and so on. No, I was very now for the question, the last question about a new kind of conduct that might raise. Honestly, if you think of new kind of conduct, in a sense, the antitrust conduct are remain the same. It's just like they find different ways to perform, to engage in anti-competitive practices, but yeah, so far the rules are the same, so we don't really deal with new antitrust practices in the legal sense. And now, with respect to the bias, that's a very interesting question, in a sense, the comment of Daniel related to the fact why antitrust will fit more than other other fields in law in in the use of AI systems. So I think that the antitrust has a great responsibility because it's the first arm of government regulation, in a sense that can reach any governments before the Congress has time to enact a new law and or to have a new regulator. So antitrust is the first arm of government regulation. So this is why I think is particularly compelling the exploration of the adoption of this technique in the field of antitrust. And also it's compelling to see if these techniques raise like bias, because it might mean that there is a bias in the enforcement of antitrust law. So
you have 10 seconds.
Okay, so thank you very much to all of you for your amazing question and for keeping the community full of thoughts and really I truly appreciate and we will work on your comments and questions, and we hope to see other proof of concepts, other projects in this way. And so thank you also.
I'm going to try to nudge them to write for us indeed, but Ashwin, for now the floor is yours for the conclusion in 1 minute.
Yeah, I will try to be very brief. So so we see where the field is evolving, and we see that AI has the potential to create much welfare, but also much harm. So it needs to be very well regulated. But as we say, too much regulation kills innovation, and we need to find we need to work on the thin line between too much innovation and too much regulation. But AI is a wonderful tool, but it needs to be properly regulated.
Yeah, yeah. This is why I think what you said before related to the involvement of people with different
and sociologists, etc. Indeed.
Yeah.
Daniel, the floor is yours for the conclusion.
Yeah, so I mean, Thorne McCarty's point is a great one. Like, how do we find approaches where we can combine, use what we already know to improve these tools? Of course, what Giovanna and Ashwin were doing is a proof of concept, right? And showing how we can use these tools and trying to prove that out. And again, I really appreciated the work. I love to see computer scientists and legal experts working together. And yeah, we've been working on projects of court data projects, for example, here at Northwestern, where it's so great to have people, not just in computer science and law, but from other fields, sociology, journalism, right? And I think we need to see more and more of that work. It's difficult to do in the academy, right? And most of us are not incentivized to do that work. And then having these conversations, we need to have more of them so we learn to have better conversations and develop the vocabulary and the body of research so we can produce more and more of the work that we need. So thank you for organizing this, Thibaut, and thank you for your research, Giovanna and Ashwin. Glad to be a part of it.
Well, thank you very much, David.
Oh, I just want to say thank you. The coding part was doing that, getting the structured data out of the things is great. And I'm just going to put a plug for, I'd love to see the code and data. I feel like I could solve so much confusion.
All right, thank you very much. I will just conclude in a few words. First of all, thank you very much for staying up late with us. For those of you in Europe, as I am, we have a packed schedule tomorrow. In fact, we'll be together for 4 hours instead of 3. You'll hear from MIT, Chicago, and Toronto academics on how to improve merger control by studying the tech which is being acquired instead of just focusing on the turnover and the market shares. You also hear from a computer scientist on the inside of the Microsoft case and how to automate remedies in the field of antitrust. And finally, you will have presentation from 3 antitrust agencies, which is, I believe, a world first, and it will be explaining which use they make of computational tools in 2021, or at least for what is not a business secret. So see you all tomorrow and take care. Thank you very much. Bye-bye.
Thank you.